In the middle of your medical malpractice trial, I am questioning you, the injured patient. And now, during my questioning, I ask you what you spoke to your doctor about, Dr. Jones, about the treatment that he recommended. And all of a sudden, the defense lawyer jumps up out of his seat and yells out, "Objection, Judge, that's hearsay!" Is that really hearsay? You want to know what hearsay really is and whether or not this objection is appropriate? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Okay, first of all, what is hearsay? Hearsay simply means, hey, listen, you're telling me about a conversation you had with somebody else. That other person with whom you had that conversation isn't around for me to question them. I have no idea whether what you are saying is true. You're telling me one version of the story. That other person is nowhere around. I can't question them, I can't find them, I can't ask them questions about the truth of this particular story. So now I have you on the witness stand. I am asking you open-ended questions. That's known as a direct examination that occurs during the course of trial. And the whole purpose of that is that since you, the injured patient, are the one bringing a lawsuit, the jury wants to hear from you in your own words exactly what happened. So I will ask open-ended questions. Mr. Jones, tell us what happened next. Where did you go next? What did you do? What did you hear? What did you observe? Who, what, where, when? Let the jury understand in your own words exactly what happened. So now I ask you to tell the jury about a conversation that you had with the doctor whom you have sued. Let's say we'll call him Dr. Jones. Okay, tell us what conversations you had with Dr. Jones when he was talking about the treatment that you needed. And now the defense lawyer gets up and yells out, "Judge, I object to that question. Oginski's question is not appropriate." And the judge asks him why not. He says, because it's hearsay. Now, think about that. Is it hearsay? The person who is being sued in this case is Dr. Jones. We have already had an opportunity to question Dr. Jones in the pretrial litigation process known as a deposition. We also call it an examination before trial. So before we ever reach trial, we will already have questioned Dr. Jones under oath in his lawyer's office, and I already know what Dr. Jones has said, what his thinking was, and what he has done. The jury doesn't know any of this yet, but they will soon. So now I want my client to tell the jury in his own words exactly what happened and what he spoke to the doctor about and what the doctor said to him in response. Now you should know something very, very important, and it's very critical for the answer to this question. In a case where it is the litigant, the person who is bringing the lawsuit, as well as the person who is being sued, in this case, the doctor, known as the defendant. In that case, my client can go ahead and talk about conversations he had with some person who is not in court. That's permitted. Why is that permitted? Because we've already had an opportunity and already had a chance to question the doctor during the pretrial process before the case ever came up for trial. So it's not simply that the doctor is not in court and now I don't have a chance to find out from him what happened. We already have had that chance. So I am permitted to ask my client questions about conversations he had with the doctor. So in this instance, it would be totally appropriate for the judge to deny this lawyer's objection. And the way he would do that is by saying objection overruled, which basically says, okay, counselor, I recognize you're making an objection. You don't think the question is appropriate, but I disagree, and now I'm overruling your objection. So go ahead and answer the question, sir. And now my client can go ahead and explain what the conversation entailed. So why is that? Because at a later point in time in the trial, we will call Dr. Jones to the witness stand if he hasn't been called already. And now each side will have an opportunity to explore the conversation that occurred and now my client is testifying about. So let's turn it around now. Let's say I want my client to talk about a conversation that he had with a doctor in the hospital after the wrongdoing occurred. I know from my client that this doctor said to him, listen, I know the first doctor screwed up. I understand he screwed up, and because of that, you will now be left with the following injuries. I want my client to talk about that. Can he do that? Well, here's a problem. Because that doctor has never been questioned, because neither side has had an opportunity to learn information about this particular witness, now it's going to be virtually impossible for me to get that information out to the jury. Why? because that would be hearsay. Because assuming that the hospital is not a participant or a litigant in the lawsuit, they were never directly sued, and this particular doctor was not involved in the lawsuit as well, and nobody ever got his testimony or a sworn statement about what he said to my client, now it is going to be very difficult to get that information out. So if I were to turn around and say, Mr. Gold, I want you to tell us about that conversation you had with the surgeon who told you certain things after your first surgery. Tell us what he said. Now the defense attorney jumps up out of his seat, yells out, "Objection, Judge, that's hearsay." And you know what the judge says at that point? That's correct, counselor, that is hearsay. The objection is sustained, which means you, the witness, cannot talk about that conversation. Now, if I want the jury to hear that conversation or learn about it, that means I have to somehow track this doctor down. I have to go ahead and bring him into court, either by a subpoena or voluntarily, and now call him to the witness stand and say, "Okay, doctor, my client told us about a conversation that he had with you. Do you remember that conversation?" He's either going to remember or he's not. In all likelihood, he's not going to remember that conversation, because why should he say anything detrimental against his colleagues at that point? So can I ask my client to go ahead and tell the jury about the details of a conversation he had in the hospital? The answer is maybe yes, and then again, maybe no. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens here at trial in a medical malpractice case in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.